education exclude all others. And Section 1415 I2C has been held by this court since 1985 in School Committee of Burlington versus Department of Education of Massachusetts to authorize tuition reimbursement.
But that was before the 1997 amendment that added 1412. The whole point is, didn't the amendment fill the gap? Because at the time of Burlington, there was an equitable consideration. There was no statute that said otherwise. And there was this gap as to children who weren't getting the public education. Then Congress said, well, wait a minute. This is a spending clause issue. This is a notice to the states issue. And they passed a specific statute with specific language, 1412. How do we just read out the language of 1412? How do we just take it out of the statute?
Your Honor, petitioner would certainly not ask this court to read the language of 1412 out of the statute, but rather to read it as applying in one particular circumstance, as Congress's effort to clarify what a parent must do before removing their child from a current public school placement. And that is indicated in subsection 3 of 1412, which is entitled Limitations on Tuition Reimbursement. Specifically, a parent has an affirmative duty to provide notice to the school district before removing their child and to cooperate with the public school while their child is enrolled there. And as the Ninth Circuit observed in Forest Grove...
But none of this applies here because your client wasn't enrolled, and we certainly have no on-the-ground, in-time indication of whether the IEP was efficacious.
Your Honor is correct that 1412 is not applicable here because the child was not enrolled.
Right.
However, that should not be foreclosure on a parent's right to a remedy, which is broader than this one subsection.
Well, if we follow up on what Judge Lippman had said, how far does your reasoning go? If there's documented evidence that a school is poorly performing and their special ed program, suppose there's a report card on special ed, and the parents have realized that the special ed in public school is sorely inadequate, then is the parent allowed to not participate in an IEP and then automatically put their child in a private setting and then demand reimbursement?
Your Honor, if the parent can prove that that school district did not offer their child an appropriate plan that was reasonably calculated to meet the child's needs.
I want you to listen again. What I'm saying is, suppose the parent doesn't consult with the school, doesn't participate in an IEP program, but has documented evidence that suggests that the school is poorly performing with respect to special ed kids. Will they then not have to participate in an IEP program and then be eligible for reimbursement?
Well, first, Your Honor, the provision 1415, which should be read to authorize tuition reimbursement in cases where 1412 does not apply, allows a court to apply equitable principles to an individual case. So a court can consider in a given circumstance whether it would be fair to provide this remedy. However, the school district has an affirmative obligation to identify and evaluate the children that reside in their district with disabilities, whether they're enrolled in the public school, in a private school.
And that happened here. The school prepared an IEP, but I'm not understanding your argument that 1412 doesn't apply. Let's look at the language. It says if the parents of a child with a disability who previously received special education and related services, and then it goes on.
Yes, Your Honor.
Isn't that a prerequisite?
Your Honor, it is.
As the First Circuit held, right, in the Greenland?
In Greenland versus Amiens, yes, did hold that that provision was the exclusive source of a court's authority here. However, 3 of the other 4 circuits to consider this have reached the other conclusion, that it is ambiguous as to whether that is the only circumstance in which a court may order tuition reimbursement, because that limiting language of a court may only order tuition reimbursement is not to be found in this provision. And in fact, at the time that Congress enacted 1412, it reenacted Section 1415 unchanged, which, as this court has stated in United States versus Shapiro, indicates an intent to adopt the meaning given to that language by this court. And
when does this limiting principle in 1412 apply?
Your Honor, when the initial requirements of 1412 are met, including prior public school enrollment, then 1412 applies. And a parent seeking tuition reimbursement will bring their claim under that provision. And
so it's only when the child is already in the school?
Yes, Your Honor.
But what kind of a limiting principle is that?
Your Honor, because...
It doesn't limit it. By definition now, it applies to no.
Your Honor, 1412 should not be read to limit a court's authority under 1415, but rather subsection 3 indicates that Congress was intending to require a court to consider a parent's duty to provide notice and to cooperate before seeking a remedy of tuition reimbursement if they were removing their child from a public
But
school.
let's talk for a minute about the states who have to pay this money. Your argument would mean that as a parent, you're better off not sending your kid to the public school. You're more likely to get reimbursement than if you do use the public school. Obviously, from a state's perspective, you want people to go to the public schools. It's expensive for the state. I think in this case, it's $24,000 a year in
Yes,
reimbursement. Is this fair to the state?
Your Honor, it is fair because a parent always bears that burden of proving that the plan is not reasonably calculated to meet their child's needs. And when they bring a claim before allowing the plan to be implemented, they must...
How can you possibly, how do you prove that for a plan that was never implemented or never in effect?
Well, Your Honor, that is likely to be difficult. A parent must prove that on its face, an IEP will not meet their child's needs.
I mean, what we see in case after case here is that, a child is working under a plan and, falls further behind grade level, and then there is real-time evidence that the plan is not adequate, and then the question are what alternatives. But here you're saying, well, that the plan in the abstract is definitive, and we're to simply look at the language of the plan and maybe listen to some experts, but we're doing this in the absence of the most critical information there is, which is whether the plan works or not.
Your Honor, and that is why a parent takes a risk in bringing this claim, because they must...
The parent takes no risk. The parent is either left where he or she started or gets $24,000, which the other kids in the class don't get. So it seems to me, from your position, it's all upside for the parents.
Respectfully, Your Honor, it is not, because the parent, as this court observed in Burlington, is taking a financial risk by enrolling their child in a private school. If the court does find that the school district's plan is not on its face inappropriate, then the parent is going to pay those costs, including the cost of litigation.
But so is everybody else in the class. That's what all the parents of private school children are going to do. They're going to pay the cost. So if it turns out that they pay the cost, they're like everybody else, and without going into the public school, if they get reimbursed, gee, isn't that a nice bonus, without having to, again, as the judge indicated, to have any real, way that we can evaluate whether the IEP was appropriate, the best way to evaluate.
Your Honor, if a parent were to place their child in a public school for a day, a week, a year, we don't even know what it takes to satisfy this requirement as respondent.
So then you don't have to do it at all, and you just go into the private school and say again, I didn't think it was any good, the IEP, reimburse me. If I don't get reimbursed, again, I'm treated no different than anybody else in that private school. And if I do, I was able to bypass what would seem to be the import of the statute.
But a parent could also, under respondent's reading, place their child for a day, an arbitrary period of time, into a public school, and then they can get the same remedy.
So what's wrong with that if that's what, assuming this provision applies to your client?